This is the Great Trials Podcast. As always, I am your host, Steve Lowry, along with my co-host, the scholarly Yvonne Godfrey. What do you think about that, Yvonne?
I like it. I like that they're not always about my really good looks.
That's right. Absolutely. I thought that would be a particularly good one for today, since we're doing something a little different today. So Yvonne, what are we doing differently today?
Calling me out. I know that we have an outline. We have a plan of things we're going to talk about today, and I didn't look at the outline of the things that we're going to talk about today because I just wanted to come into it fresh.
Oh yeah, it's definitely the way to do it. But I have let my better half listen to some of our podcasts, and my wife Leilani.
That's not me.
Yeah. My wife Leilani is always my best focus group. Always calls me out when I am spewing BS or saying something that's not making sense. And yeah, exactly. And so she suggested that for people who aren't lawyers, that we have a show where we sort of just talk through what a jury trial is and the process of a jury trial. And so I thought that it would be fun if we got a few of the best legal scholars around the nation to do this, but unfortunately we couldn't find any of them. No, just kidding. So today we are joined with my law partners, Jeff Harris and Jed Manton, and then Jeff's much better half, Rebecca Franklin Harris. And so we're going to talk through sort of what happens in a lawsuit, all the way up, up through filing the suit, all the way going through a jury trial to verdict. So that's the plan. Is everybody ready to do that?
We're ready. Let's do it.
All right. Do each of our guests want to say hello and introduce yourselves?
Hello.
Rebecca, so you're the only one who's not technically with our law firm of Harris, Lowry, Manton. So why don't you give a little plug for your law firm?
Sure. My law firm is Franklin Law. I'm married to Jeff. I'm Rebecca Franklin Harris, and I've said many times that I like to work with Jeff and not for Jeff. So I've got a separate firm. We work on cases together.
Wait, why don't I have the same option? Because I work for you every day of my life.
This is why it's set up that way. We work on the same kind of cases and do similar work. We've tried cases together. We've tried cases separately. And I'm glad to be here. Thanks for including me.
Yeah, and you're in practice with your dad, Jimmy Franklin?
I am. He practices in Statesboro, Georgia, and I'm in Savannah. And it's a father-daughter team and somewhat of a husband-wife team. Mm-hmm. So it's very incestuous around here.
This is Georgia. Be careful. Why don't you tell everybody your website if they want to look you up?
Sure. It's I think it's www.franklinlawllc.com. Do you have to say www?
I'm so glad you said that. You don't, and Steve says it every time. And every time I'm like, I gotta tell him not to say the www anymore. Okay, so scratch that.
Actually, what I'm going to start saying is the World Wide Web.
Yeah, he had.
Will you type all that in?
Yeah, Steve had me gone to www. But we're hoping to just get rid of the W.
Yeah.
So franklinlawllc.com.
He's pounding that out on his 800-pound IBM PC.
Exactly. All right, so what we're going to do, and I do have an itinerary, and I think at least some of you have looked at it. So just sort of the different things that we need to talk about a trial. So the first thing, and we can talk through this kind of quickly, but enough so that we can explain what exactly happens. But Jed, since you've been quiet this time, why don't you talk about how a lawsuit gets started with the filing of a complaint and an answer and what happens in that process?
Sure. Thanks, Steve. Thank you for having me on your podcast. I've heard a lot about it. And,
From who?
Many times where I've tried to reach you to ask you questions and heard that you were podcasting. The filing of a lawsuit starts with you have to go down to the courthouse and file a complaint. And that's what starts the process. Now, there's a bunch of stuff that goes on before a lawsuit gets filed, where you're investigating, analyzing claims, figuring out what your case is about. But since this is kind of focused on the trial aspect of things, I'll just fast forward to the point where the lawyers or the law firm, they've done the investigation, they have an idea about what the case's basic facts are, who's likely responsible, and then they have to draft a formal pleading, take it down to the courthouse, pay a filing fee to start the process. From there, that basically lists out your allegations, what you think happened. And in some case, you already know when you file your lawsuit what happened. You know, if somebody ran a red light, you got a police report and a witness that you can talk to, and it's very easy. Most of the cases that have probably been discussed during this podcast are much more complicated and had a whole lot of facts, and a whole lot of time went from filing of a lawsuit to, you know, the ultimate trial in the case. And that's kind of the next phase that happens. So you file your lawsuit, you have to send it to the people that you've sued. They get served by a sheriff, and then they have to come back and tell the court, okay, we either agree or don't agree with what's, you know, contained in the lawsuit. Very rarely do they agree. They usually say, look, we're not responsible, or have some other counter story. So you go into a phase of what they call discovery, and that's where the lawyers for each side, the person bringing the lawsuit and the person that's defending the lawsuit, have the opportunity to gather facts in a more formal way, take depositions, which are just legal statements taken from someone under oath, exchange documents, go talk to people under oath that are not necessarily involved with either party. They might be witnesses, or they could have been, you know, former employees, things like that, talk to doctors. So that goes on for an extended period of time. We could probably talk about that for quite some time. But after all that happens, eventually you'll get to the point where the court says, okay, now's your time. Now's your time to come in. You haven't been able to settle your case and present your facts to the jury. So that's kind of how you go from, you know, a piece of paper to getting, you know, to the jury in, you know, less than 2 minutes.
Yeah, and I should add that the filing, just so when we sometimes throw around legal terminology in this case, the filing that the defendant files when after a complaint has been filed is called an answer. And so when lawyers talk about the answer, they're just talking about what the defendants responded to the complaint.
I also feel like this is a good time for me to point out that as far as when you serve the complaint on defendants, it wasn't until I went to law school that I thought you got served was really just a dance battle phrase until law school. I actually didn't know what you got served meant until law school. So it's not the dance battle kind for
I don't know what dance battle means.
It's sort of like Footloose, Jeff.
Yeah, there you go. Exactly.
I got it. Which, by the way, was awesome.
right, exactly. That brand new movie. Right, and then Jed talked about discovery, and we talked through that pretty quickly. But you know, as we know, discovery can take a very long time before you get ready for trial. And Rebecca, you've done a lot of discovery and been extremely helpful in that in a lot of our cases. You want to just kind of walk through that process a little bit?
Sure, I'll be glad to try to put everyone to sleep because this is by far the most boring part of the case. But it is the longest part. I heard somebody say recently that if you think of a sheet cake that you get from the grocery store, the trial is the icing. It's what you see, is what you think about, it's what you sort of decorate. But the discovery is the cake part. So you can't really have a cake without the cake part. But it's the boring part. But it's the biggest part, and frankly, sometimes the most important part. So Jed mentioned a sort of a regular car wreck case. Even in something that's simple like that, the discovery can be pretty extensive. You know, if you're a plaintiff and you say you've been injured, you can't just file the lawsuit and say, I've been injured. You have to show that the other person was at fault, and you have to show that your injuries were caused by that. So, you know, the defendant has a right to discover information about your injuries and what you were doing at the time to make sure that you weren't at fault. And so that consists of written discovery, which is people writing answers to questions, producing documents like medical records, and then taking depositions, which is essentially like a trial, but not in a courtroom. So you give testimony about what happened. So takes the longest. Again, not the most exciting part of trial, but probably the most important part of any case.
Yeah, we recently had Russ Herman on, and he had a great quote that he said that 10 seconds of inspiration during trial doesn't make up for 4 years of preparation. And so, and the point is that all that work that goes into it, it makes for a great trial, and discovery is where all of that preparation happens. And so discovery can take, I think in the standard case it's supposed to take 6 months. It almost always takes longer, and then many times it can actually take years before you get to trial. And then the next thing, so basically after you finish discovery, there's a time for motions where the defendant can ask for things to be dismissed. Yvonne, do you want to talk about the motions just quickly, and then the pretrial motions, like motions in limine? When we say motions in limine, what are we talking about?
Yeah, so you mean like motion for summary judgment and that
Right,
kind of thing?
exactly.
Yeah, so after discovery is completed, or potentially while discovery is still happening, defendants can file dispositive motions to try to get rid of the plaintiff's case or part of the plaintiff's case. So they can file a motion for summary judgment and say, based on the undisputed facts that have been shown by the facts gathered in discovery, there is no way under the existing law that the plaintiff can recover. So they'll file motions like that. This is before you get to trial. This is before the pretrial conference or anything like that. And so you normally get, that's a time-consuming process too, because at least in Georgia, with any motion that's filed, you get 30 days to respond to it at a minimum if you don't get extensions or anything like that. And then you might have a hearing on it for a motion for summary judgment. So that part can be pretty time-consuming. And then and then after that, so if you survive, if you lose a motion for summary judgment on all your claims, then the case is over. So sometimes I think that's come up where Steve and I have been asking questions about getting past motions for summary judgment. If you lose a motion for summary judgment, your case can be done and there's no trial, that's it. If you survive the motion for summary judgment, then you start getting into sort of the pre-trial motions that are leading up to trial. So that's when you will be thinking about your pre-trial conference. You'll have motions in limine to bar certain types of evidence.
Which, by the way, what does motion in limine stand for? In the
Great
original
question,
Latin?
Jeff.
In limine is
What is-
Latin.
It's not limine.
Is that Latin for lemon, or what does that mean exactly?
Isn't it for like in the middle, or like
thought it was
while
to
things are
limit.
going on? Isn't it? You know the answer, right?
Anyway, moving
Yes,
on.
What is it?
of course we know the answer, but we're going to move on
I
anyways.
think in limine means like while
Basically, it's
things
just
are
a
happening.
way of getting a pre-trial evidentiary ruling on something that you anticipate will come up at trial, and the court can go ahead and rule on it before it comes up. And it comes from the Latin in limine, which means lemony, which is kind of an acidic taste. Leaves in your
And
in your
as
mouth.
always, I
Or-
think Rebecca actually has the answer.
Or simply preliminary, according to
Well,
Wikipedia.
Some people think that. But
Right. I mean, sure, if you want to simplify
sure,
it.
sure. If you want to be all Latiny correct about the whole thing.
So, but when we talk about motions in limine, I mean, what are you asking the court to do, or what are the parties asking the court to do?
So you're asking to prevent any evidence, like Jeff said, that you think might come up that should not be admissible, to prevent that ever being brought up in front of the jury at all, any
Right.
references to it. So an example would be like we normally file one on references to plaintiff's lawyers seeking jackpot justice or
Right.
something like that. Something that ahead of time you think a defense lawyer is going to pull, and so you file a motion with the court to get a ruling ahead of time to prevent certain references or evidence from being admitted at trial, because once it is, it's hard to unring that bell.
Right. And it can help move the trial along so that, once you're in front of the jury, the trial will go hopefully a lot smoother, that you're not constantly running up to the judge or making objections. Hopefully things will move quicker and more efficiently.
Right, because this actually relates to something that Jeff and I were talking about just the other day about how, do you want to talk about that, Jeff, about how, it's kind of related.
Remind me of what we were talking about.
How the boomerang thing or the scarcity principle. Why don't you tell people about it?
Yeah, there's a famous study that basically says that if a jury if something comes into evidence at trial that shouldn't come into evidence, and then the jury is given what's called a curative instruction by the judge. The judge tells the jury, you heard the following and you are to disregard that thing, whatever it is you heard, which happens frequently at trial. The studies basically show that it has the exact opposite effect. It's the scarcity principle. If the jury's told to disregard something, the thing that they're told to disregard actually becomes more important to them than it would have been had it just come in otherwise. Because it's sort of like, don't go in that closet. Whatever you do, don't open that door and look in there like your kids, whatever. Right. And of course they're going to open that door and look in that room because you've told them that. And otherwise they probably wouldn't have cared. So.
Right. And it's also what we talk about when we make objections at trial. Usually what you're doing is just highlighting whatever you were just objecting to. And then the jury's like, well, I wonder why they didn't want us to hear that.
Yeah. Right. So your motions in limine have to be good and get a good order on them, and then hopefully all the parties really stick to them. Because otherwise you can end up in that situation.
So after all of that stuff, you are essentially ready for trial. One thing I did want to talk about is, and we've talked about this on a couple of podcasts, are focus groups or mock trials. Jeff, do you want to explain what a focus group or a mock trial is and why those are so important?
Jed, we have to talk about the fact that Jed is picking his nose, taking liberties because this is a podcast.
It's a podcast.
Right. He thinks he's not on camera, but he is.
Which also
this is being recorded.
Which also explains his general appearance too, as well. All right. So before a trial starts, most lawyers will take a shot at trying to see how a jury would receive the case. And the way you do that is with either a mock trial, which is a fake trial, or a focus group. And you bring in people who typically come from the same venue, the same place that you would try the case. You try to get a representative sample of people in terms of ages and socioeconomic backgrounds and all that sort of stuff that would be similar to what your jury would look like. For example, if you're trying a case in South Georgia, it doesn't do you a whole lot of good to go get a bunch of people from San Francisco because they may view the world differently. And so you try to get people who are representative of what your jury's going to look like. And then you focus group your case. You can do it a variety of different ways. You can focus group specific issues. You can say, well, how do people feel in general about med-mal or medical malpractice cases? Or you can actually try an abbreviated version of the entire case to the focus group. And you're doing that so that you can determine what your case looks like and how the jury ultimately will decide the case. Over the years, we've done a zillion focus groups, and I'm always shocked at how closely a case tries to what the focus group tells us it's going to look like when it tries. And what you're also hoping to do is if you're going to try a case and you're presenting arguments that aren't any good, or you're making arguments that aren't very persuasive, your intent is to learn that before the trial starts, because as the old joke goes, the most expensive focus group you can ever have is the actual jury. So you're trying to make sure that your case is put together well, that it's persuasive, it's compelling, and the way that you learn that before trial is to do a focus group. The mock trial is essentially the same thing. It's just a little bit more formal. You actually have a fake judge and fake witnesses, and you present it with the formality of a trial with the constraints that a trial would impose, and a focus group's a little bit more freewheeling.
Yeah, and to add to that, since the holidays are coming up, I sort of think of a focus group, at least the more informal ones, to be sort of like Thanksgiving dinner when everybody's sitting around and Jeff and I start to tell our family about a case and they tell us that it sucks.
Yeah.
And so, and that always happens pretty much every Thanksgiving, and that we're going to lose, and that's really what
Which is why I'm looking for another family. And,
or at least
go ahead and tell her.
Thanksgiving at Applebee's. So anyway, that's okay when the focus group comes back and tells you that you have problems in your case. That's a good thing, and it's always been helpful for us to hear the negative comments, not just the positive.
Yeah, in fact, and as I said earlier, Leilani is my first focus group. I run all my cases by her, and I've had cases that I thought had real problems in it, and she listened to it and she goes, I think you're going to do great in this case. And then I've had other cases that I thought were pretty good, and she sounds like you got some real problems in that case. And yeah, I mean, and in fact, as you were saying, Rebecca, I mean, you want to hear the negative side of it. I mean, that's more important than just having a bunch of people saying, great job, you have nothing to worry about, just go in there and try the case. I mean, you want to hear your weaknesses. And Jeff, I always give the example of the power of focus groups or mock trials when I think of our Hamby versus Daimler Chrysler case. Do you want to talk about what happened to us in that focus group and how it changed the trial?
Yeah, we had a case years ago that involved a defect called the brake shift interlock device, and there's a device where you have to push down on the brake in order to shift a vehicle into gear. And what had happened in that case was a child was in the vehicle and was able to shift the vehicle into gear. It rolled down a hill and it ended up killing another child. And we thought it was a very strong case. And one of the issues is, what the defense is always, well, you can never allow a child access to a vehicle. It would be a terrible parent that would allow that. The truth of the matter is it happens every day of your life. You have your kid in the car, you pull up to the mailbox, you get out to check the mail. Well, the kid's in the car, or you put your kid in a car seat and then you run back into the house to get something that you forgot. I mean, on a daily basis that occurs. But at any rate, we thought we had a really strong case against the automaker for not having a device in the vehicle that would prevent it from being shifted without the brake shift interlock device. And we focus grouped it. And the focus group basically said it was pretty clear we were going to lose, and we were going to lose bad. Right. And I remember us all leaving the focus group going, because this case had gone on for years. We'd spent zillions of hours and a lot of money on it and a lot of energy and effort.
Well, and not to mention that we had just started our brand new law firm.
It was our very first case that was going to go to trial after the formation of our law firm. And so we were gonna come out with a huge fizzle. Is what the focus group
That's what it looked like.
was telling us. And so, we left the focus group, we got this feedback from them, and we completely retooled the case. We completely revamped just about everything we were planning on presenting to the jury in that case, because we knew that if we didn't do what the focus group told us that we needed to do to win, we were going to get our butt kicked. And we ultimately won, and I'm convinced that we won because we did what the focus group told us to do.
Yeah, absolutely.
What didn't they like?
What they didn't like was the fact that that the parent had left the child in the vehicle by herself. And in reality, that's not exactly what happened. The mother's boyfriend was washing the car, and he had Madison playing in the vehicle, and he had it turned off, or at least what he thought was off. And he had walked, I think we figured out he had walked 17 feet away from the vehicle to get something, and then that's when the vehicle started rolling. But what ended up, and so the jury, the focus group really did not like, that argument that you leave a child by herself in the vehicle and that that's not the parent's fault. And so the biggest change that we made was, we had our client
front loading that issue.
Right, exactly. I mean, we talked about that, in voir dire and through openings, through everything. And then when our client took the stand, said, "Do you take responsibility for what happened?" And she said, "Yes, I absolutely do. And I'm hoping that Chrysler or Daimler Chrysler will also take responsibility for what they did in this case." And so what it allowed Jeff to do in closing, and we're going to talk about this when we get to closings, is the fact that the plaintiff gets to go first, the defendant goes, and then the plaintiff gets to do rebuttal or have sort of bookend the closings. Is at the very end of his closing, he said, "We've taken responsibility for our mistakes. Will Daimler Chrysler take even 1% responsibility for their mistakes?" And so then Daimler Chrysler gets up there and they don't take any responsibility. And so then when Jeff came back up in the rebuttal, he said, "Well, there you have your answer. They're not willing to even take 1% responsibility." And just really, when it comes down to this issue, and we've talked about it a lot in trials, of credibility, who's got the most credibility at trial, when you have one side that's willing to accept their mistakes and their faults and say, "Yes, we made a mistake, but it's not the only mistake," and then one side that's just absolutely unwilling to do that, it really hurts that side's credibility. So that was the biggest change that I thought we made in that trial. So I guess we're ready to move on.
That's all I have.
So let's talk about the actual start of the trial. So everything's been done. You walk into the courthouse ready to start. The first thing that you're going to do, and Jed, I'm going to ask you to talk about this, is voir dire or jury selection. So you want to talk a little bit about what happens during the jury selection?
And let's go ahead and start with voir dire too, the Latin for that, since Yvonne's handled in limine. Jed, what's the voir dire mean in Latin?
To speak the truth.
And actually in South Georgia, they pronounce it voir dire.
Yeah, that's right.
I thought it was French.
French, Latin, whatever.
Yeah. Well, French is a Latin-based language.
And I thought it was like see and speak.
Moving on.
Rebecca?
I think Jed gets most of the points.
And I just since this is a podcast, I just don't want anybody who listens to this to immediately assume that Rebecca is the smartest of all of us, because what she's doing is sitting here Googling the answer to these questions.
Pretty much Wikipedia. It's a legal phrase for a variety of procedures connected with jury trials. It is Latin, and it means to say the truth. So there you go.
Ouch.
Good job, Jeds.
I took French for 6 years.
All right, we're gonna let Jed, since he's 1 for 1, go ahead and explain this.
Yeah.
Right. So jury selection, and probably the biggest misnomer that a lot of people that are not familiar with the courtroom process, that maybe have gone through it before, the public gets the summons, they get to come in, and they're going to go through this horrific day of being shuttled around the courthouse from courtroom to courtroom, and you may or may not ultimately get picked to be on a jury, which is most people's goal when they get their summons in the mail is, gosh, how do I get out of this? But ultimately what happens is that for each case, a panel of potential jurors will be brought into the courtroom. And to start with, the judge will ask some basic questions to see if people have some relationship to the case or the parties, or what our legislature has said are automatic disqualifications from serving on a jury. So these things can range from, okay, my brother's sitting in the panel, that wouldn't be fair to have my brother on the jury, or someone who is related to one of the parties. It may very well be that you're a student. A lot of people don't realize that's an automatic right to be disqualified. If sitting on a jury would take you away from classroom time, you can actually get a deferment for that. So there's some legal different things that can get you, excluded from jury. Most people don't fit into that category of having a legal disqualification. So then the judge turns it over to each of the parties to ask a whole bunch of questions with the hopes of finding out who are good potential jurors. It's a little bit of a misnomer, because it's not like any other test we have where the more things you get right, you're considered better. So it's not like if you answer more questions and you say more things, you're like, well, this is a really great juror for this case, we're going to put them on to hear the case. Actually, what happens is each side is going to have the opportunity to remove a certain number of potential jurors, and whoever is left creates the jury pool. So a lot of times what happens is the people that don't say anything, thinking, gosh, if I can just slide under the cracks without bringing any attention to myself, I might, not get selected to be on this jury. Well, generally what happens is it's the people that are really opinionated that say some things that cause one side or the other to be hesitant that that person could be fair, and so they end up getting removed. Another thing that can happen is a person can say so many things that are, obviously showing that they have kind of prejudged the case without hearing any evidence, and the judge can just exercise his or her discretion and say, look, this person's just not right for this case, and remove a person for that. So at the end of the process, each side goes back and forth. The judge has removed certain people because they have a legal disqualification. The judge has removed certain people as potential jurors because they've said something that just makes it sound like they're leaning one way or the other. And then from who's left, each side gets a certain number of strikes, that they call it, to remove people from that last pool. And then who's ever left, that's your jury.
Yeah, and there's all kinds of theories, and as we talk to the different lawyers about the cases they've tried. I mean, one of the most important, if not the most important part of trial is jury selection. But there's all kinds of theories on how you do this, how you're looking to either find jurors that are going to be problematic and you need to remove them, or to have them removed for cause. And I'm not sure I heard Jed say it. So Rebecca, do you want to explain what the difference between a peremptory challenge is and a challenge for cause?
No.
Why, you can't go to that fast enough?
I've never been good at explaining
Right.
the difference between a preemptory challenge and a challenge for cause. I mean, essentially, a challenge for cause is a challenge for, you move to exclude a juror because they have some sort of bias they bring in, and they essentially can't be fair. Jurors often won't say that they can't be fair, but they'll say things that would lead the court to believe that they should not be a proper juror, and that is it's discretionary. And then I'll let Yvonne take what a peremptory challenge is.
That's basically where each side gets a certain number, and then you can strike somebody and you don't have to say why. This is too bad it's a podcast, because you should see how relieved Jeff's face was that I knew what
Well,
Yeah,
and
exactly.
the reason I didn't want to explain it is because it seems like a peremptory challenge is simply just striking the jury.
That's right.
So that's what I call it. So a
Yeah.
challenge for cause is just when you've got your set number of strikes, but challenge for cause is so you don't have to use a strike on someone who should not otherwise be on the jury.
Right.
So
Well, what the law says is there's certain things that, as a matter of law, preclude someone from being on a jury. So if you're married to the defendant in a criminal trial, then if you end up on the veneer, which is the group of people you strike the jury from, there's certain types of strikes that are legal cause, which means the judge has to strike them no matter what. And in addition, there's sort of another category, which is, as a legal matter, if you say, I can't be fair, and I don't care what the evidence is, I couldn't listen to the evidence and I couldn't be fair and objective, that's another legal basis for making sure someone doesn't sit on a jury. If you get over those legal hurdles, then the second kind of group of strikes are the lawyer can just get rid of, in a civil case, basically 6 jurors for each side for any reason. If you just don't like the way they look at you, if you just have a bad feeling about them, you can strike those jurors. The only restriction on that is a constitutional restriction that says you can't strike someone based on their race, and that comes from a series of Supreme Court decisions. But short of race, a lawyer can get rid of, in this second phase, if there is no legal reason for striking them, you can just get rid of them for whatever reason. In fact, you ask your client, is there anybody on this jury that gives you the heebie-jeebies, which is a legal term of art from Latin.
That's right.
And you can strike them at that point.
And
Yeah.
we've talked about with a bunch of the people that we've interviewed so far about jury selection and how many potential jurors were brought in, and that's partly because, for Tab Turner's case, if you've listened to that episode where his was about issues of terrorism, so you're going to have a lot of people that have a lot of convictions or beliefs that they might, in front of the judge, say that they're not sure that they can disregard, or they're not sure that they can be fair. Issues that involve religion, things like that. So then you need more potential jurors. So that's why in Tab's case they had over 1,000.
Yeah. Well, and as we heard from Russ Herman, if you guys can imagine this, sometimes a judge wants to keep you a couple of hours for picking the jury. His jury selection in his tobacco case took 18 months.
Wow.
Wow.
Well, and that's probably a good time to talk about how tiring jury selection can be. I mean, I can't imagine 18 months. I mean, typically the cases that we're involved in, jury selection takes up to a day. I'm not sure that we've ever had it go more than a day, but it can be a long day. And Jeff will remember one trial. It was a big case. We'd been working on it for 3 years. We'd been preparing for trial for months and months, and it was very stressful. And we were dating at the time, and had not really spoken about anything but the trial in a few weeks, and not on very good terms because of the stress that was involved. Mostly his fault, but anyway.
Right.
So
I'm sure it's all his fault.
we get into voir dire, and he gets up there and starts talking to this panel, and all of a sudden he is just a rock star. I mean, the women on the jury, the panel where they would blush when he would talk to them, and the men were like wanting to go have a beer with him, and I was like, who is this guy? I haven't seen in forever. So sometimes I'll ask him when he's in a bad mood, I'll say, I'd really like to be married to or to date voir dire Jeff rather than the actual Jeff that I'm married to. But
It's too tiring.
my point is that it's a stressful process for the person asking the question. It's also stressful for those who are sitting there helping, watch and helping take notes, because it's, people are answering questions quickly, the judge moves it along, and you typically only have 10 minutes to sit down and figure out what strikes you're going to use. So it's a stressful part of the
And
job.
one of the hardest.
Right.
Yeah.
It's one of the hardest things to do at trial.
We've talked about how you've got to be doing so many things at one time, even if you're not the lawyer who's actually conducting the questioning. If you're, my role is typically to sit there and take notes about how the jury, how the potential jurors are responding to questions, but you're looking at them and trying to keep track of what they're saying, but you're also trying to keep track of the look on their face and the look on other jurors' faces and the people who aren't saying anything at all. It's a lot to pay attention to, so it definitely is such an exhausting day. The fact that you have to just show up the next day and go right into the trial is crazy.
And what's even harder, and Jeff and I both had to do this a couple of times, is when you go right into openings right after voir dire, and it's
on the same
exhausting.
day.
Yeah,
On the
I
same
mean,
day,
with
yeah.
maybe a 15-minute break.
Yeah.
So. But one thing we didn't explain is if anybody who's ever sat through a jury selection, I mean, when we actually do these peremptory challenges, it's when they pass the piece of paper back and forth between the parties, and you put your strike number one, and you cross them out, and then you pass it over.
Right, because the potential jurors are sitting there, so if you ever wondered what they were doing, that's what they're doing. Right? Yeah, they're in the room by then.
Yeah, they're in there, and I'll never forget when I was sitting on the jury panel one time, and I was juror number 7, and I was in the box, the jury box, answering questions, and then the lawyer turned his sheet towards me, and I saw a big X through number 7, and I was like, oh, I guess I'm not going to be on this jury.
We should also take this chance to point out, I've never once been picked for jury duty or anything, but now,
Are you a citizen?
even if I do,
Are you a citizen?
Partly because I'm not legally here. No, I don't know if it's because I move a lot. I've never gotten picked for jury duty, but when I do, I will probably, chances are not very good for me ever to serve on a jury because I'm a lawyer. And so I feel like we should make a quick pitch, especially since the people who are taking time to listen to this episode might be non-lawyers, that you're so lucky if you ever get picked for jury duty, and it's such a
Yeah, I think we would all kill to have the opportunity to see it from the other side.
Yeah, so don't make up reasons to get out of it.
Well, it's such an important process of our system, and people have always said that our jury system is not perfect, but it's the best that's out there, and there are mistakes made, but having 12 people listen to the facts, and decide that it affects the parties is such an important part of our process. And so if we can encourage anybody to actually go sit on a jury and not try to get out of it, then we've accomplished something.
Just think about who you would want on your jury if you ever need a jury. Lecture over.
There you go. All right, so let's move on. So after you've got your jury and they're put into the box, here in Georgia it's 12 jurors, and it's got to be a unanimous verdict. That means they all have to agree, and then you usually get 1 to 2 alternates, so that if somebody gets sick or has a death in the family or something like that and has to leave, the alternate comes on. But then you're ready to go into openings. So Jeff, you want to talk about openings?
Sure. Technically, the opening is supposed to be limited to what you anticipate as a lawyer that the evidence will show once it's presented to the jury. So you're supposed to get up and say that we anticipate that the following witnesses will testify, and we anticipate that they'll say this, and kind of lay out the evidence that the jury's going to see, because it's a hell of a lot easier for the jury to absorb a bunch of evidence if they have sort of an overview of what they're going to see before they see it. And then you're allowed to talk about what the defense will be, and you're allowed to explain how the defense is going to present their case. That's legally what you're supposed to do. What really happens is everybody argues like hell until they get yelled at by the judge.
Right. You argue as much as
Right.
possible.
Right,
So-
and it's an opening statement and a closing argument.
That's
So
right.
the opening statement is supposed to be a statement.
Which is why in trial, over and over again, one lawyer will stand up and say, "Judge, he's arguing," and then the person who was arguing will have this look on his face like, "What? Me arguing?"
Exactly.
And then the judge will say, "Counsel, quit arguing," and then that goes on, and then the other guy will get up and start arguing, and so it's kind of lawyers walking the fine line between arguing their case, which they're not supposed to do in opening statement, and outlining their case, which is sometimes a fine distinction that is difficult to draw, but that's the purpose of opening statement.
Yeah, and one thing I didn't talk about that we should discuss is this concept of burden of proof. Yvonne, you want to take burden of proof? Who has it and what is it?
The plaintiff has
Right.
the burden of proof by the preponderance of the evidence.
In a civil case,
In
right?
a civil case,
Yeah.
more likely than not. And so that's why plaintiff gets to go first, right?
Yep.
I
Right.
mean, I don't know if that's technically why, but
No,
the
it
plaintiff
is.
always gets
That
to
is
go
exactly
first.
why.
Okay.
Yeah.
Whoever has the burden of proof
Yeah.
gets to go first.
Yeah, so it's your burden. So if it's a tie, then the plaintiff would technically lose if you couldn't show that it was more likely than not. Is that what you mean? Is that what you want me to say?
Yeah. No, I mean, it's just important. I think it's important to explain that when the plaintiffs walk in and they've brought this lawsuit, I mean, it's the burden is on them to prove why they should prevail in the case. And
Right,
so,
right, yeah, and it's different than the criminal burden of proof. It's not beyond a reasonable doubt, and you start making sure the jury knows that even during jury selection and making sure they understand what everybody's burdens are. But I think sometimes that's hard for our clients because, bringing a case, litigation can be stressful. Being deposed can be stressful, but it's your decision to file the case, and it's your burden to prove your case. So.
yeah, and it's why sometimes, I mean, the defendant, in theory, doesn't have to put on any evidence at all because they don't have the burden. So they could just literally challenge the plaintiff's case and not say anything when it comes to their time to put up their case, and they could win.
Right.
All right. Well, so after openings are done, both sides give their sort of overview of the case and why they think they should win. Then we move on. The plaintiff will start what's called the plaintiff's case in chief, and that is essentially all of the evidence that the plaintiffs are going to put forward. Rebecca, you want to talk about some of the evidence that's put on in the plaintiff's case in chief, like expert witnesses, fact witnesses, that kind of stuff?
Sure. Well, it depends on the case, obviously.
Right.
But typically, the plaintiff will start with some witnesses, and you start by doing a direct examination of a witness. And so the plaintiff calls, let's just say a car wreck case, and you represent the person who's been injured. You may call a witness who saw the accident to say that they believe the light was red, which is a fact that you would need to prove in the case, and so you would do a direct examination of them. And a direct is, I kind of think of it as like a commentary on CNN or Fox News or whatever, where the person asks this witness or this person questions, and it seems like it's a conversation, but generally the Anderson Cooper knows the answer to the question before they ask it, and it seems kind of like a dance. That's how you want direct examination to be. They say, the old saying is that you don't want to ask a question on direct examination you don't know the answer to. So it's harder than it looks, but typically the plaintiff will take fact witnesses. They'll do direct examinations. If there are experts involved, those tend to be a little bit longer, a little bit more in depth, but it's the same concept. You put up your evidence by asking witnesses questions, and then the defendants get to cross-examine those witnesses, which you might want to talk about. So.
Yeah, I absolutely want to talk about cross-examination. And I want everybody to sort of chime in, but for our part of the case, for the plaintiff's part of the case, I mean, we cross-examine in the defendant's case, and so when the defendants put up their evidence, then we'll do cross-examination. There is one exception to that, and Jeff, maybe if you can talk about that. This is that in a lot of cases, since the plaintiffs have the burden of proof, they'll want to put up either the defendant or a corporate representative of a defendant, so of a corporation, and present that witness in their case in chief. You want to talk about that a little bit?
Yeah, sure. So as Rebecca was explaining, if you're talking to a fact witness, you ask that witness questions, and you're not supposed to lead the witness, which means you're not supposed to suggest the answer to the question in the question itself. But and you typically have to do that in your case. So you're calling people, you're saying what happened, when did it happen, where did it happen, etc. But in your case, in the plaintiff's case, you can also call the defendant for purposes of cross-examination. So if the defendant is a person, in the car wreck example, the guy who's hit by the driver who's the defendant in the case, you can call the defendant on cross and you can ask the defendant leading questions. Isn't it true that on the day that this accident happened, you were drunk, or that you didn't wear your glasses that day, or whatever? And the defendant at that point in time can be crossed and can't tell his side of the story. And the reason it's set up that way is precisely because of what we've been talking about. The burden of proof is on the plaintiff. So you can call the witness up and lay the elements of your case out through cross-examination. If you're dealing with a corporation, you can do the same thing, but since a corporation is not a person, you have to call a witness who's a corporate representative. So you can call the Ford Motor Company as a good example, for purposes of cross-examination, and you can say, isn't it true that Ford has known for 100 years that if you put the gas tank behind the rear axle and next to the bumper, that if someone hits the car from the rear, the car is going to blow up like a mushroom cloud? Your question would be a little tighter than that, but you get the point. And what you try to do in that scenario is it doesn't matter what the witness says, because if he disagrees with you, you have a document that you can what's called impeach the witness. You can prove that what he just said isn't true, or the answer, whatever it says, whatever his answer is, you're going to win either way. Isn't it true that the Ford Motor Company values safety?
Right.
Okay. If the witness says, no, we don't, chalk up a point for the plaintiff. Yeah. Or if the witness says, yes, we do, then you get to your next point, which is, well, why the hell didn't you design this car in a way that was safe? So that's kind of how you call people on cross in your portion of the case.
And I think it's important for us to quickly take a step back to say that if you've never seen a trial and you've maybe only seen them on TV, it's really important to know that when you put a witness up, it's all question answer. They don't get to just sit up there and talk about what they want to talk about, whether it's on direct examination or cross-examination. It has to be a question-answer format. The testimony that they give has to be in response to a question. So just think that's important if you watch a lot of how to get away with murder.
Like TV questions always drive me crazy, where the person will just stand up and start making a speech on law and order, and
or
every lawyer's going, oh, come on.
Yeah, or they're making their closing argument, and not even paying attention to the witness anymore, just talking to the jury.
Right, and related to that with surprise witnesses and things like that, we didn't spend a lot of time on it, but part of the motion in limine and the pretrial conference and all that process is each side, for the most part, knows what documents the other side has, what they're going to use as exhibits, what witnesses they're going to call, or at least potentially going to call. So
yeah, the TV where everybody turns around and stares at these doors and some guy walks in. It doesn't happen.
Yeah.
One thing I did want to say about the corporate representatives, it's that sometimes can be hard for people to understand, is that while this might be John Doe sitting up there on the stand, it's not, you have to imagine, it's not John Doe answering for himself.
Right.
He's answering on behalf of the corporation. So it's as if Ford Motor Company is sitting there on the stand and Ford Motor Company is talking to the jury.
Yeah, and it's a strategy that corporate defendants use all the time. They'll try to have what we call the know-nothing corporate representative. Right. So the guy who's representing some huge corporation doesn't know anything. And that actually is pretty helpful to us.
Yeah.
It's like, really, you're the guy that they pick, the guy who doesn't know anything about how the product was made? So, but it's a tough spot for the corporation to be in, because if they actually bring in a knowledgeable witness, then you can prove a lot of points. But if they bring in somebody who's clueless, well, that proves a point as well.
Yeah, absolutely. So another type, and during all of this time is when we'll be presenting evidence. And so, like for instance, any documents that you want to get into evidence, and we don't need to go through the actual procedure of that, but that's the time when you'd be doing that. One of the types of witnesses we haven't really discussed, and I'm going to call on Jed to see if he can discuss this, is expert witnesses. You want to tell everybody why you have expert witnesses and what they do?
Sure. So there's a certain group of witnesses that saw something directly related to the case. They could be like even a medical doctor. They treated your client. They have firsthand knowledge of something that's relevant to the case. There's also a group of witnesses that the court recognizes that they may have specialized training or education or experiences that the average juror would not be accustomed to. So they're allowed to present on the expertise that they have. So think of Jeff had mentioned, a case against a product manufacturer or an automobile manufacturer. You would have expert witnesses that are engineers that would come in and explain engineering concepts to the jury. And they would, not just do it in the abstract, but they would explain the engineering concepts that relate to the particular vehicle that was involved. So they may have reviewed, thousands of pages of underlying, engineering drawings and CAD drawings and photographs related to the vehicle. They may have gone out and purchased a vehicle that it was the same make and model as the vehicle that your client was driving, to tinker around with it, to, figure out how it functions and how it could have been designed better and things that could have been added or changed to prevent certain things. The type of number of different types of expert witnesses is almost, it's huge. I mean, you have expert witnesses that might come in a medical malpractice case and explain, okay, this is what the doctor should have done. He or she did not do certain things, and that's why this patient was injured. You could have another expert for the other side, a medical doctor, come in and say, look, this doctor who's been accused of doing something wrong did everything correctly, or he or she may have not done it exactly like I did it, but both ways are reasonable ways of doing this procedure. So expert witnesses are there to help a jury better understand certain technical issues that relate to the specific case. Now, another thing that needs to be pointed out, the expert witnesses are not brought in by the court or a third party to give an objective opinion. They are hired by the parties. So, during plaintiff's case, what we're talking about right now, these are witnesses that the plaintiff has gone out and hired to present certain facts. And then likewise, the defendants will have the opportunity to do the same thing. There's a lot that goes into that, but there's certainly, if you have someone that you're just paying them money to say something, then they're going to get beat up very bad on cross-examination. And Steve mentioned earlier about the true underlying success aspect of a trial generally is winning the battle of the credibility in front of the jury. So you got to pick your experts wisely, and you want to make sure that they're going to come off as credible, even though they are being compensated for their time.
Jed, you're doing a really good job with your questions, and I'm wondering if Steve told you ahead of time what questions you were going to get.
Right, and also you keep looking at a teleprompter.
Right, yeah, exactly.
Because I want that teleprompter.
I've not done any casework in the last 2 weeks preparing for my podcast.
Right.
What was worth it? You're doing a really good job, and meanwhile I'm getting asked what in limine means in Latin, which is
Right.
in limine.
It's from the Latin in limine.
Exactly. One thing, just following up on Jed's point, is that expert witnesses, like he was saying, they are paid, and sometimes that can become a big point of the cross-examination of that expert witness, especially if they've worked for the same party a number of times and then been paid thousands, sometimes hundreds of thousands, sometimes millions of dollars from that party. It is a fair question to ask them how much they've been paid and whether or not that would affect some bias they may have. In some cases that we've had, where we've actually had expert witnesses who've been paid close to $100 million by one corporation.
Right. I think we would all agree that in our next life we're coming back as expert witnesses,
Right, exactly.
having paid them a lot of money on both sides.
Yeah.
And clients often ask when a case settles or when it gets ready to go to trial why the expenses are so high. Why is it that we've spent so much money on a case, and it's almost always because the experts are so expensive.
Yeah, and you know, like Jed was saying, I mean, so when they're doing their work to investigate what happened, they go and in a auto products case, they look at the vehicle, they go to the scene, they may purchase a vehicle, they may do a series of their own testing where they're running crash tests or something like that, and so all of that. It takes a lot of work and is not cheap and is expensive.
Right, and the thing is, I think you need it. You know, just like the jury needs it to understand a certain issue. You know, lawyers end up working on a case so long that they become sort of experts on the particular defect or the thing that's involved. But you really, I mean, the first products case I ever worked on was a tire case with Jeff and Rebecca, and a lot of the issues were about how you build a tire and what goes into making a tire and what the ingredients are, and you know, even spending a lot of time on it. I think I started with the firm maybe 4 or 5 months before that trial. I didn't understand everything about it, and a jury is definitely not going to understand everything about it. So you need those experts to help explain those issues to a jury. Number one, because the lawyer really can't, and number two, because it's something that's beyond the ken of the average of the lay person. So you need, you know, they're expensive, but they're necessary.
Rebecca, go ahead and tell us what the halabutyl content of that tire was.
And what the hell is halabutyl? Yeah. One other thing before we rest the plaintiff's case I wanted to talk about and is the importance of demonstrative evidence, and what do we mean when we talk about demonstrative evidence. And I can see I'm making eye contact with Yvonne and she's shaking her head, so I'm going to ask Yvonne to talk about it.
Waving you all.
No, I was actually thinking that we didn't spend a lot of time, you mentioned it, but it's just because it's kind of boring, but you know, you have the kind of evidence like the documents and stuff that you're tendering for admission through through regular witnesses. If it's a police officer who comes in to talk about a car accident, then you get in the police report through that witness. And these are things that are admitted as exhibits and will go back with the jury for their deliberations.
And one thing we should say is that, you know, our paralegals don't get near enough credit for all the work that they do in these cases. But I mean, the reason why when we take a witness, say like a police officer, and we've got a set of photographs, you know, or the reporter or something we get in, I mean, they help us, and we'll make sure that we have a checklist says, you know, are these your photographs you took at the scene? And that's basically the way that you go about getting that into evidence.
Yeah, and in some trial, if it's a big trial, you may have, we've had cases that go to trial where we've had 5,000 exhibits. You're not going to tender that many, but you may have that many. But, you know, I can't find my checkbook. I mean, I can't find my car keys.
I've got it.
Yeah, okay. She's got it. But, you know, imagine the chaos if I was trying to keep up with 5,000 exhibits. So Steve's right. We have great paralegals who keep all that stuff organized and help us find the exhibits and get them tendered and get them ultimately to the jury who looks at them.
Don't you think you need to give a shout out to Bob?
And that's where I was going to give a shout out to Bob, and that's why I wanted to talk about demonstratives. And I think Yvonne did a nice deflection of demonstratives there.
I think Rebecca should talk about demonstratives.
or just Bob.
Yeah.
No, we, you know, I think that over the past probably 20 years since shows like CSI and Law and Order have become so popular, juries expect the lawyers to have a dog and pony show, and they expect the lawyers to have videos and, you know, really, really good graphics, and they expect for, you know, documents that may be otherwise boring to be put up on a screen and call outs and all this stuff that you couldn't do before the technology allowed it. So we typically have a trial tech person who comes to trial with us, who actually starts preparing before trial, weeks before trial with us, to make sure that the trial is seamless, and that, you know, when Jeff says put up the x-ray from September 2014, Bob knows what that is, and he can put it up and he can make it look sexy, so to speak. And so, you know, if you can afford a trial tech guy, if the case can justify the expense, we think it's always a good idea. I've never gone wrong doing that.
Yeah, and we're saying Bob, so we should probably say his name is Bob Poston, and he works for Legal Technology Services. That's who we use, and he and his company have been fantastic during trial. Again, demonstratives.
Yeah, okay. So you can use things
Somebody gonna answer his question.
You can use things like medical illustrations, so it's not an actual medical record from somebody's treatment, but it's an illustration that illustrates what the injury was or what kind of disease or illness somebody had. You can have what we call exemplars, but a sample tire that's like the actual defective tire that you had in the case, or you guys want to talk about some of the products ones, like a box?
Let me
Some of
take
the
a shot on
builds,
this
right.
demonstrative thing.
Okay.
All right, so there's actual evidence and then there's demonstrative evidence. And so in a murder case, someone gets shot, there's the murder weapon, the gun that shoots them. That that gun goes back with a jury. They can look at it and hopefully not shoot themselves in the toe or anything like that. But then there is evidence that isn't actual evidence that demonstrates some point. Now, from an evidentiary standpoint, the jury can weigh both those things equally, which a lot of people don't recognize. I mean, demonstrative evidence is evidence that can prove your point. But like if somebody has a bullet hole in them, and then there's a medical illustration that shows what the bullet looks like inside the body, well, you can't you can't bring the corpse into the room and send it back with a jury. You've got to have something that demonstrates how the bullet hole went in and what happened inside the body. So you have groups of evidence. There's stuff that actually is evidence and stuff that demonstrates some evidentiary point. So illustrations, animations, like a lot of people have seen animations where there's an accident and somebody, because the accident happened 20 years ago, you got to have somebody who comes in and does an animation to show you what it looked like. That's demonstrative evidence. Is that what you were looking for?
Yeah, that's exactly. Thank you, Jeff.
You're welcome, Steve.
Hey, a good
Glad to be here for you.
A good example of demonstrative evidence was from the case that we talked to you, Jeff, and Andy Scherfius about when we were talking about other incident evidence, where in an auto products case, if you've got an incident, in that case it was a seat back that had fallen down or in a crash and broken the spine of a little girl, that you can talk about other cars that were made by the same manufacturer where that seat has come loose and fallen down. And for instance, in that case, one of the demonstrative exhibits that Jeff and Andy had in that trial was essentially a chart that showed, I don't remember what number you had, but it was a number of other incidents that Ford knew about where this same thing had happened in the same vehicle, the same type of vehicle. So that's another use of demonstrative evidence, and we like to try and get creative about it. And most trial lawyers, who we have on this show and that we've watched, put a lot of time and effort into demonstratives that simplify the case and explain it well to the jury. So I'm going to rest the plaintiff's case. I mean, is there anything else we need to talk about on the plaintiff's side? That is what we say in trial. We say the plaintiff rests. And
one thing that I think juries get confused about is in a case where someone's injured, you might bring in a bunch of fact witnesses, relatives, people who know the plaintiff to talk about how this injury has affected the plaintiff. So if, let's say you're in a horrible accident, you can't walk. Well, you can bring in a medical doctor to talk about the broken bones, but the fact that it's dramatically changed the plaintiff's life and maybe affected their marriage and affected their family relationships, a huge part of the plaintiff's case that involves a personal injury or some kind of wrongful death type case is going to be dedicated to fact witnesses that talk about the injury. Juries are confused about that, and a lot of times it's the plaintiff's lawyer's fault for not explaining an opening statement why they're going to see that. But I've had them tell me over the years, like, well, we just didn't understand why you're bringing in all these people to talk about, what happened to them. And so that's going back to this opening statement. That's the reason why you outline what the evidence is going to be, so you can kind of tell them how it all fits together, so they'll have some, way of understanding why you're bringing that witness in.
Right, and what I guess we should say, and I didn't really explain this, is that when we talk about that the plaintiff has the burden of proof in an injury case, basically you need to prove that something happened to you and that somebody was at fault for that and the defendant was at fault for that, and then once you prove that they were at fault and they caused your injury, then you need to prove what those injuries are and what effect that's had on you or your family, and we refer to that as damages. And so what Jeff is talking about would be in the realm of damages type evidence, where we're at the end of the case going to ask the jury to award some amount of money to compensate the plaintiff for the injuries. And so that's why you have those types of witnesses explain how much of an effect this has had on the plaintiff. Good point, Jeff.
Thank you.
So at the end of that, essentially at the end of the plaintiff's case, the plaintiff rests, and by that point the plaintiff should have put up enough evidence, or all of their evidence, to prove every point of their case. That something happened, that somebody was responsible for it, the defendant was, and that they were injured, and it was caused by the defendant, and that they're entitled to damages. And that's when you would rest your case, and they talk about that. There's a legal term called the prima facie case, if the plaintiff had put up enough to prove their case.
Don't even say it.
Which means what?
I know, I don't actually know.
It's prima for first, prima, and fascia for first fascia.
First fascia, that's right.
Rebecca, let's
I see Rebecca is quickly.
legal terms expert, Rebecca Franklin Harris.
Based on what I can remember from law school, it's prima facie means based on the first impression accepted as correct until proven otherwise.
Right, there you go.
As I remember it.
Yeah.
As I remember.
So, and at that point, it's time for the defendant to start their case, or their case in chief. And
Stop you right there.
Sure.
Clearly, this is going to be a two-part podcast.
It
We're
might
just
be
halfway there.
Well, except that I think we're going to go a lot faster through this section.
One thing that I think people don't understand is, because you hear people talk about runaway verdicts and juries being out of control and all that other stuff, is how many procedural stops there are along the way before a verdict is rendered. And so after the plaintiff rests their case, the defense at that time moves for a directed verdict. And what they can say is the plaintiff hasn't met their burden of proof, and the judge gets to stop it right there. And that happens all the way through. So when you file the complaint, they can file a motion to dismiss. Yvonne talked about a summary judgment motion, which is after the close of discovery. Well, now the trial starts. In the middle of the trial, there's another sort of procedural impediment to the plaintiff's case proceeding, and it's a directed verdict. And the defendants can say, before they've put up any evidence at all, they can say, Judge, the plaintiff hasn't met their burden of proof, throw this thing out. So that's what happens after the plaintiff closes their case.
And the jury's not there for that. A lot of those, so they don't know that that's happening. They're all.
The judge will say, we've got some matters we want to take up outside the presence of the jury, and that's what's going on when the judge does that.
Yeah.